The facts. Today, we're putting the justice system itself on trial. A recent Gallup poll found that American confidence in our courts has plummeted to a record low, just 35%.
Wow.
People on both the left and the right feel that the scales of justice are being tipped. The question is, why? Are judges becoming political actors in robes? Or is this a misunderstanding of how our judiciary is meant to work? Here to help us unpack the facts is Elena, a legal analyst, and David, a former legal counsel. Welcome to you both.
Glad to be here.
Thanks for having us.
So let's start with that staggering number. Only 35% of Americans have confidence in the courts. David, from your perspective, what's driving this collapse in trust?
Alex, I agree that trust is collapsing, but this erosion of trust began decades ago.
Okay.
It happened when the public saw liberal courts consistently finding new rights in the Constitution that simply weren't there. Decisions on everything from the rights of criminals to privacy felt like they were coming from a legislature, not a court.
Right.
What many see as a conservative shift today is actually an attempt to restore the judiciary's proper limited role, to say what the law is, not what they think it should be. The distrust is a hangover from decades of judicial overreach from the left.
I see it differently. I'd argue this is a full-blown and more recent crisis of legitimacy, and it feels deliberately engineered.
How so?
When a Supreme Court majority, appointed through a highly politicized process, overturns a half-century of established law, as they did in Dobbs, which overturned Roe v. Wade, it sends a clear signal. The message is that precedent and stability matter less than achieving a specific political outcome. The public sees that, and they rightly conclude the court is acting as a political body, not a judicial one.
This brings us to a tactic that's been in the headlines, court shopping. Elena, let's start with you this time. What is it, and why is it so controversial?
Analytically, court shopping, or form shopping, is the strategy of picking your courthouse to get your judge. The most blatant example in modern history came from the right in the Mifepristone case.
Right.
The anti-abortion groups who wanted to ban this FDA-approved medication didn't file their case in Washington, D.C. or a major city. They filed it in Amarillo, Texas.
Okay.
That's a division where 100% of such cases go to one man, Judge Matthew Kaczmarek, a judge with a long, documented history of opposing abortion. It was a calculated move, and when you rig the system to get the referee you want, conclusively, you can't be surprised when the public thinks the game is fixed.
Well, Elena's right that it's a playbook, but she's forgetting who used it so effectively just a few years prior.
Well,
It's the perfect example of lawfare. Whenever the Trump administration issued a major policy like the travel ban, opponents wouldn't just sue, they would strategically file their lawsuit in a place like the District of Hawaii. Why?
And why there?
Because they knew they'd draw a judge appointed by a Democratic president who was likely to grant a nationwide injunction, an order from a single judge that blocks a policy for the entire country. It became a playbook for paralyzing a presidency, and it's a clear abuse of the system.
So we have clear examples where both sides are accused of exploiting the same loophole. This gets to the heart of the judicial activist charge. David, when you hear a case like Roe v. Wade described as activist, what does that mean to you?
It means the court went beyond its authority. I call Roe v. Wade activist because it invented a constitutional right to abortion. Based on a vague right to privacy that the justices essentially created from whole cloth. What the Dobbs court did wasn't activism. It was a correction. It was an act of judicial restraint that returned a contentious political issue to the democratic process, where it belongs. The left tends to label any ruling that curtails judicial power or returns power to the states as activist, when in reality, it's the opposite. It's allowing the people, not 9 unelected lawyers, to decide.
But that's a very selective view of activism. From my perspective, Citizens United is pure activism. The majority in that case overturned years of precedent
I disagree.
to enforce a political vision that benefits powerful special interests. There is no historical basis for equating corporate spending with an individual's speech. That's not interpreting the Constitution. That's rewriting it to fit a specific deregulatory ideology. And it's a pattern, ignoring precedent, or stare decisis,
Right.
when it's inconvenient for a particular agenda.
It's clear the definition of activism depends heavily on where you stand. Let's pivot to solutions. In March of 2024, the Judicial Conference announced a new rule.
Yes.
It aims to require random assignment of judges for cases that could block state or federal laws, directly targeting that single judge division problem. David, is this the fix we need?
I'm deeply skeptical,
Okay.
not least because a number of chief judges in federal circuits are already indicating they won't enforce it, arguing it's an overreach. The idea that a procedural tweak can solve a philosophical divide is naive.
I see.
On principle, the only real long-term solution is a commitment to a consistent judicial philosophy, textualism and originalism, that constrains judges from imposing their own views. The problem isn't the rules of the game. It's that too many judges think they can be the star player instead of the umpire. Appoint better umpires and the game will fix itself.
I see it as a critical and necessary first step. It closes the most egregious loophole
But
that allows for the kind of blatant judge shopping we've been discussing. But let's be honest, it's a bandage, not a cure.
right.
It doesn't address the lack of a binding ethics code for the Supreme Court, nor does it touch the hyper-partisanship of the confirmation process. More fundamental reforms like term limits for justices need to be on the table to truly depoliticize the court.
So we end where we began, with a deep division. We have a crisis of faith in one of our most vital institutions, fueled by accusations of politicization from all sides. And while there's some agreement that procedural games like court shopping are a problem, there is no consensus on the root cause, let alone the cure. Now, here's a question we'd like you to think about. If we accept that all judges have personal views and experiences, is it more dangerous for them to try and adopt the Constitution to our changing times, as a living constitutionalist would, or is it more dangerous for them to bind us to the 18th century understanding of the men who wrote it, as an originalist would? Which path poses the greatest risk to justice?